Thank you very much, Mr. President. Good afternoon, colleagues. I'm here today to present to you all for consideration Senate Bill 1393, a bill to bring us closer to a fair and just form of sentencing. This bill would restore the court's discretion in the interest of justice and at the time of sentencing to strike sentence enhancements for prior serious felony convictions when a person is currently charged with another serious felony. Under current law, one of the most commonly used enhancements is the mandatory 5-year enhancement for prior convictions of serious offenses, which is applied consecutively for each prior conviction. Sentence enhancements for prior convictions consistently result in elongated periods of incarceration and are the main contributors to prison overcrowding. While most sentence enhancements can be declined if the judge believes they are unjust, this enhancement is mandatory in all cases. By restoring the court's discretion, we can return to a time where judges have the ability to tailor enhancements to fit the actual circumstances. Sentence enhancements, colleagues, are double jeopardy. They will continue to be so even in the case of judicial discretion. It's important to remember, however, that these are incremental steps towards unwinding the massive public policy failure known as mass incarceration. Stakeholders opposing this legislation all strike a similar chord, expressing an inherent lack of trust in our correctional system to rehabilitate our fellow Californians. I've said it before, but I'll say it again. More time does not equal less crime. Some groups have said that there are no scenarios in which a judge would strike this enhancement. This sounds to me like a clear lack of trust in our arbiters of justice. Lengthy prison terms do not deter crime, they do not reduce recidivism, and they do not help with rehabilitation. What they do lead to are broken families, high financial burdens to counties and the state, and lack of opportunity for our fellow Californians. It should be noted that this fair and just sentencing reform would simply return judicial discretion back to the judge's hands, which was in effect before our disastrous tough on crime and mass incarceration public policies passed by this body. These mandatory sentence enhancements have created a harsh and arbitrary system where punishment is disproportionate to a person's culpability and do not serve the interests of justice or public safety. With that, I ask for your aye vote.
Senator Mitchell, would you like to close?
Mr. President, yes, if I may. First of all, colleagues, let me just say that I personally am very uncomfortable with the multiple references on this floor today and the correlation drawn between the discussion and passage of sound public policy and the electoral process. I think it's inappropriate and a dangerous trend. Not to mention, I think it's grandstanding and I don't appreciate it. I also guess I have to adjust my own expectation. I have to stop believing that members of this body can change either. That based on research and study after study after study, that could influence and inform a decision, an attitude, not a decades-old life experience. And so, like my colleague just said, quote, they don't change. Perhaps I shouldn't have the expectation that people on this floor have the capacity to read and learn and change either. Facts, my colleagues. The crimes will not go unpunished. A judge, a member of the bench, will be allowed to view a person's full circumstances. There is already a substantial base term for these serious crimes. Other enhancements get stacked on the base term for things like gang affiliation. This bill does nothing about that. Don't forget, colleagues, 3 strikes is indeed still in place. If this bill becomes law, judges will be allowed to impose the strike enhancement, the 5-year enhancement, both or neither. It gives the court maximum discretion. The people we are talking about today have already served time for the previous crime they committed. SB 1393 would allow the judge to determine if they should serve the enhancements based on their current situation. As I have repeatedly asked my colleague from Tehama to actually give us a research-based citation that validates his assertion that crime was indeed less during the heyday of our tough on crime era, I will do what I've asked of him, as I've done in the past. As soon as I find it in my notes. It's the 2014 444-page report published by the National Academy of Sciences, where they reviewed all available studies on the effects on crime, effects on women, families, communities, and concluded that, and I will quote, "Given the small crime prevention effects of long prison sentences and the possibly high financial, social, and human costs of incarceration, federal and state policymakers should revise current criminal justice policies to significantly reduce the rate of incarceration in the United States. In particular, they should re-examine policies regarding sentence enhancements." These bills are about addressing the racially disparate impact of having so many men and women, fathers and mothers, snatched from our communities and our families. The inference that I haven't spent time with victims of crime, haven't done my work to have a balanced perspective on what California really experiences, is offensive. I have done just that. There are victims of crime groups who lobby us, who work these halls, who are proponents for criminal justice reform. There are victims of crime organizations who fundamentally understand and acknowledge the fact that they also don't want to live in a state that has a history of mass incarceration, a state who is under a court order to reduce its prison population without a strategic approach. We have evaluated and are looking at the sentence enhancements and are taking a critical look at which enhancements are not working, which enhancements further violate one's constitutional protection against double jeopardy. Colleagues, I would argue that SB 1393, which empowers the judicial branch to do the job we expect of them, does just that. With that, colleagues, I appreciate the robust debate, and I ask for your aye vote.
Ayes 23, noes 14, the measure passes.